It is important for you to have a will if you are a person over the age of 18, regardless of the size of your estate and assets you may have. Do you ever think to consider what happens if you were to die without a will? If you die without a will in the province of Ontario, you are dying intestate, which results in your estate being subject to a statute called the Succession Law Reform Act. This statute dictates a fixed order of distribution for your estate if you do not have a will. Essentially, the government, pursuant to the distribution rules contained in the SLRA, gets to determine the distribution of your estate. If you do not have the will, you cannot comment on how to do this distribution. Your property also goes through a will as an asset management office that previously belonged to the deceased. This process is more costly and lengthy as it must be supervised by a court that allows the appointment of a trustee and the distribution of assets and the payment of asset debts. If you have minor children and no will appointing guardians for such minor children, the court gets to decide who are your children's temporary and permanent guardians through a guardianship proceeding. This is a very important decision for your children's best interests, and it is critical to select someone you trust to fill this role. If you are unmarried and in a common law relationship, there is no statutory right for a common law partner to inherit from your estate. You could potentially disinherit your common law spouse without intending to do so. Creating a validly executed will can avoid these issues by addressing and setting out your specific wishes in the document. Make sure to contact the right professionals when creating your estate plan, and make sure your will is effective and up to date.